welcome to Crime in Court. My name is Heather, and this is another update in the Marcellus Williams case. So, this is part of my Innocence Lost wrongful conviction series, and we've talked about Marcellus Williams a couple times now throughout this series because he is continuing his legal battles to get his case overturned because for some reason they are fighting adamantly to execute an innocent man. So it's a tragic story that happens all too often in our country, and we need to shine a lot more light on these things happening. So, anyways, let me give you a bit of an overview. So, Marcellus Williams, he's been obviously wrongfully convicted, and there is currently DNA that has come to light, and it exonerates him, but yet he's still sitting in a Missouri prison. So let me play this quick little news clip, which tells you about where we're at. So they were trying to get his sentencing vacated. But the problem is his execution date is looming. It is September 24th. So, in order to mitigate that, he was his lawyers were able to strike a Alford plea, which basically is you're familiar with like the staircase, the Michael Peterson case, um, and who else? I think the Central Park. No, West Memphis 3. They all took an Alford plea to get out of prison, basically time served, so that Damien Eccles wouldn't get executed. This is kind of the same thing where this Alford plea was offered to Marcellus in the hopes that it would keep him from being executed, and also it could buy him some time to free up this evidence that's there's still whatever trying to debate. Now there's some possibility of some kind of tampering with the evidence, the DNA evidence that's supposed to exonerate him. So let's he was supposed to have a hearing on the 21st, I believe, of August. And that, well, I'll let the news crews tell you what happened there. So here we go.
The Missouri Supreme Court stops the sentencing that was supposed to happen this morning for Marcellus Williams. He's the man on death row convicted of killing former Post-Dispatch reporter Leisha Gale. The Power of Two's Chris Renier is in.
So the sentencing, meaning the Alford plea sentencing, the Alford plea that he was taking was basically that he would get life without parole, but that would vacate his execution sentence. So that's basically what the deal was for him. However, this sentencing hearing where he was going to go do this, he was going to take this Alford plea, it got canceled by the who did she say? Let me scroll back. Start over.
The Missouri Supreme Court stops the sentencing that was supposed to happen this morning for Marcellus Williams. He's the man on death row convicted of killing former Post-Dispatch reporter Leisha Gale. The Power of Two's Chris Renier is in Clayton with the latest developments on this ongoing legal saga.
This is Fox 2, St. Louis.
Marcellus Williams was supposed to be sentenced this morning here at the St. Louis County Courthouse after agreeing to a plea deal yesterday that would have spared his life. An execution date for Williams has been set for September the 24th. But that sentencing has now been postponed after the Missouri Supreme Court granted a request by Missouri Attorney General Andrew Bailey to stop today's proceedings.
Andrew Bailey. Who's Andrew Bailey? Oh man, where is it?
That would have spared his life. An execution date for Williams has been set for September the 24th. But that sentencing has now been postponed after the Missouri Supreme Court granted a request by Missouri Attorney General Andrew Bailey.
Missouri Attorney General. The Missouri Attorney General is trying to execute an innocent man. Missouri Attorney General reached, like, not reached out, but not reached out like, "Hey, man, can you do this for me?" But they filed an appeal with the Supreme Court to to stop this Alford plea from happening or the sentencing hearing from happening. So I don't
Bailey
know.
to stop today's proceedings. Williams was convicted of stabbing to death Leisha Gale inside her suburban St. Louis home back in 1998. Williams has always maintained his innocence, and in January of this year, St. Louis County Prosecuting Attorney Wesley Bell filed a motion to vacate Williams' conviction based on DNA evidence that was not available at the time of the murder. Missouri Attorney General Andrew Bailey opposed.
So it's new evidence. He's tried everything. He's tried appealing. He's tried um, multiple times continuing or appealing his execution sentence. So he's constantly getting told he's going to be executed and this is going to be your final day. And then, oh, yeah, execution vacated or moved to another day, whatever. No big deal. Not like we're dealing with humans and their emotions and lives or anything like that.
Opposed that motion and wanted to proceed with the execution. A hearing was scheduled for yesterday where we expected Judge Bruce Hilton to decide whether Williams' conviction should be overturned. But after a lengthy meeting between attorneys, it was revealed that the DNA evidence was mishandled and potentially contaminated. Judge Hilton agreed to vacate Williams' original conviction, then Williams entered an Alford plea. That means Williams maintains his innocence but acknowledges that prosecutors have enough evidence to likely convict him. Under the Alford plea, the first-degree murder conviction against Williams would stand, and Williams would be sentenced to life in prison without parole, but he would avoid the death penalty. However, Attorney General Bailey opposed that deal and filed a writ with the Missouri Supreme Court to stop.
Why? Like, why? Why oppose it? I don't understand the Missouri Attorney General wanting to so hard to and trying so hard to execute an innocent man when the prosecuting attorney in this case has come forward and said, please vacate his conviction. We messed up. Please get it right. But yet, why are we fighting it again?
Stop the sentencing from moving forward today. The Supreme Court granted Bailey's request, saying that Judge Hilton must either hold an evidentiary hearing on the DNA that was supposed to happen yesterday or make a case for why he should be able to move forward with the sentencing under the Alford plea. The judge set a hearing for next Wednesday to review evidence on the DNA that some thought might exonerate Williams in this case. We will see what happens at that hearing.
So again, he just continues and continues down this legal battle where nothing's ever answered. Things are all always up in the air and in limbo. This is very frustrating for anyone who's, running out of patience, running out of time. I would be extremely frustrated when you're like, here, I have the evidence that exonerates me. And they're like, nah, you can just rot in prison until, whenever. We don't want you to get out. We don't care about justice. This is insane to me. All right, so attorney, this is the recap after the August 21st evidentiary hearing or uh, sentencing hearing. Sorry, it's confusing because there's like multiple things happening at once. So, attorney's statement. Missouri Supreme Court blocks agreement between prosecutor and Marcellus Williams to prevent execution. Sorry, my tongue is doing its own thing today. All right, so a new evidentiary hearing is scheduled for Wednesday, August 28th, and we'll read the recap of that too shortly. So, according to this, yesterday, which would have been August 21st, 2024, Marcellus Williams, this is Innocence Project, by the way, which is one of my major sources that I use. I also use the National Registration of Exonerees, which is a good one too. All right, so yesterday, the 21st, Marcellus Williams, an innocent man scheduled to be executed in Missouri on September 24th, entered an Alford plea in exchange for a sentence of life without parole. Again, I think I forgot to mention an Alford plea basically is you consenting, like you're saying, hey, I didn't do this. I'm innocent, judge, but I agree that the state has enough evidence that could prosecute me and convict me. So even though I'm innocent, there's enough, at least circumstantial, if not physical evidence, that a jury could potentially think that I'm guilty of this crime. So you're basically admitting I didn't do it, but it could maybe look like I did it. So it's not really a win, but it is in a sense that now Marcellus, if he was able to enter this plea on that day, then he wouldn't be facing his execution coming in less than a month, which is scary. All right, so he entered this Alford plea. The resolution would have ensured that Mr. Williams is not executed for a crime he did not commit. Today, however, the Missouri Supreme Court granted Attorney General Andrew Bailey's writ application. So it's this Andrew Bailey guy that we're mad at, okay? The Attorney General Andrew Bailey, his writ application, and the Supreme Court then blocked the St. Louis County Circuit Court from resentencing Mr. Williams to life without parole, which was going to be his sentence with the Alford plea. So, Andrew Bailey, write him, find him, yell at him, whatever, call him and yell at him. He's a public figure, he deserves it. Let Marcellus go. Mr. Williams has always maintained his innocence in the 1998 homicide of Felicia Gale. No physical or forensic evidence has ever linked Mr. Williams to the crime, and his conviction was based on the incentivized testimony of two unreliable witnesses. And this happens frequently. Prosecutors oftentimes will seek out some kind of testimony from a prison snitch, someone who will rat out, or not even rat out, but lie to save themselves from their own sentencing. I think that jailhouse informant testimony should not be allowed because I don't think it's reliable. Most of them, if not all, people in jail may have some kind of form of self-motivation to see that they get the lesser of the charges or the lesser of the sentencing, which oftentimes the prosecutors will promise them if they testify a certain way in a case. So if a prosecutor doesn't have enough evidence to really convict someone, they might go to the jail and find some informants that they or some people that they know, some other convicts that they know are facing charges that if they are willing to testify falsely, they might get some time off. And that is a crime, but it happens often because try to prove it. It's difficult, um, but it does happen all the time. And prosecutors have this qualified immunity, which is bogus. Judges and attorneys have this thing called qualified immunity, where basically you can't come after them, you can't sue them most of the time for your civil rights being violated and things like that because they're just doing their jobs. Yeah, okay. Anyways, so prosecuting attorney Wesley Bell, he's the one that's coming forward. He moved to vacate Mr. Williams' conviction after new DNA testing excluded him as the source of the male DNA on the weapon. A hearing on this motion was scheduled for August 21st, but after the parties learned that the prosecutor's office had mishandled the knife, corrupting the DNA evidence, they reached an agreement. So this is how this Alford plea came about. After the parties learned that the prosecutor's office had mishandled the knife, corrupting the DNA evidence, they then reached an agreement to ensure that Mr. Williams is not executed as he continues to seek additional evidence of his innocence. So basically, the defense has this card up their sleeve now because, hey, we know the prosecutor screwed up. So we'll take an Alford plea, please. And in the meantime, we're going to continue to take you down. That's what I make of that. All right, so despite the fact that Ms. Gale's family does not support the DP, in this case, so the victim's family is advocating to stay his execution and just give him life. They don't want, even if he is guilty, they're thinking, don't execute him. So, despite the fact that Ms. Gale's family does not support the DP, in this case, Attorney General Bailey has vigorously opposed the motion to vacate and has pressed to execute Mr. Williams. So, again, all your hate mail, please send to Attorney General Andrew Bailey. After the circuit court accepted Mr. Williams' Alford plea yesterday, A.G. Bailey filed a writ application to the Missouri Supreme Court, resulting in today's decision, which was that they are scheduling an evidentiary hearing, which was scheduled for Wednesday, August 28th. Below is a statement from Tricia Rojo Bushnell, an attorney for Marcellus Williams. After careful consideration of the applicable laws and facts, the circuit court accepted the consent judgment overturning Marcellus Williams' conviction in exchange for Mr. Williams' Alford plea and a subsequent sentence to life without parole. This agreement was made with the support of the very office that prosecuted Mr. Williams and secured his sentence, and who now concedes constitutional error, and with the support of the victim's family. Yet, in spite of this, the Attorney General has fought to invalidate that agreement. It is impossible to understand who this decision serves and what justice it provides. This decision directly contradicts the will of a duly elected prosecutor and the community he represents and the wishes of a family who has already lost so much. This is not justice. We look forward to presenting the evidence that supports the circuit court's decision at the hearing next week, meaning supporting the Alford plea. So now this article was written and posted on the 28th. So this is the 21st was the first hearing. Then they scheduled a evidentiary hearing, which is the 28th. This is that. Attorney statement. St. Louis County Prosecuting Attorney concedes constitutional error by prior administration in Marcellus Williams case. The Office of St. Louis County Prosecuting Attorney Wesley Bell conceded that the prior administration committed constitutional errors contributing to Marcellus Williams' unreliable homicide conviction and sentence. This was written August 28th. Today, the Office of St. Louis County Prosecuting Attorney Wesley Bell conceded that the prior administration under Prosecuting Attorney Bob McCullough had committed constitutional errors contributing to Marcellus Williams' unreliable homicide conviction and sentence. These errors included mishandling a key piece of evidence that could have exonerated Mr. Williams, like the weapon with DNA on it. like the perpetrator's DNA, perhaps. So, prosecuting attorney Bell had filed a motion to vacate Mr. Williams' conviction in January 2024 after conducting a comprehensive review of the case, including new DNA analysis that excluded Mr. Williams as a source of male DNA on the weapon used for the crime. Despite the fact that no reliable evidence has ever connected Mr. Williams to the 1998 homicide of Felicia Gale, and that Ms. Gale's family has made clear they do not support his execution, Attorney General Andrew Bailey has vigorously fought to prevent the court from vacating Mr. Williams' conviction and to execute him on September 24th. Why? Just why? They don't want to admit fault? Is that it? But the prosecuting attorney has already said that they were at fault. Fault has been blamed already. So uh, by not by continuing with his conviction to execute him, you're also going to take fault. Attorney General Andrew Bailey. All right, so the circuit court had set a hearing on prosecuting attorney Bell's motion for August 21st, but on the eve of the hearing, P.A. Bell discovered that the homicide weapon had been mishandled by members of the trial prosecution team whose DNA was identified on the knife. Prosecutors' team members, somebody, mishandled the knife and their DNA got on it. Awesome, right? Okay. So as a result of this development, I mean, this helps Marcellus tremendously, but it also sucks because it's like, well, now the DNA was compromised, so can we trust that his DNA wouldn't be on there, blah, blah, blah. So it becomes a whole bigger problem. But the fact that it was compromised and tainted with the prosecutor's DNA, I would think that that would make that piece of evidence um y- not you can't bring that in a trial, I would think. um if he were to get a new trial today, that might be thrown out, that piece of evidence that has the prosecutor's DNA on it. Maybe they're the perpetrator. So, as a result of this development, the parties reached a consent decree where, in order to prevent his execution, Mr. Williams agreed to enter an Alford plea and accept a sentence of life imprisonment without the possibility of parole. The victim's family supported this resolution, which would have brought closure to the legal proceedings while ensuring Mr. Williams remains alive if new reliable evidence of his innocence is revealed in the future. So they have to, I don't know. They would still have to wait to see if anything comes out, but at least this would keep him from having to be executed. A.G. Bailey, however, opposed this agreement and filed a writ of prohibition in the Missouri Supreme Court. That court granted a preliminary writ ordering the circuit court to proceed with a hearing on P.A. Bell's motion to vacate. So the court granted the writ ordering the circuit court, so the lower courts have to have a hearing on the prosecuting attorney this is confusing. The prosecuting attorney Bell's motion to vacate. It gets confusing with P.A. Bell, A.G. Bailey, and I keep getting Bailey and Bell confused in my head, so whatever. All right, so the circuit court held that hearing today. So they had their evidentiary hearing. So we're probably just waiting now on the circuit court's decision. In addition to acknowledging that the previous office of the St. Louis County Prosecutor was responsible for mishandling the weapon, P.A. Bell, the prosecuting attorney Bell, also conceded error resulting from the state's destruction of fingerprints that were left out of serological fluids that were left at the crime scene and from the trial prosecutor's improper removal of Black prospective jurors on the basis of their race. That could get them a new trial. That could get them a new trial if there is some kind of showing, something to show that the prosecutor was striking all of the Black prospective jurors so that only white people were on the jury. That's crooked. That's not right. All right, so these serious constitutional errors, PA Bell acknowledged, undermine the fairness and reliability of Mr. Williams' conviction and execution sentence and require that they be vacated. So, all these things together, the fingerprints that got destroyed, the prosecutor's improper use of striking prospective jurors based on their race, and the whole knife that was mishandled, all those things means his sentence should be vacated. He should be freed. Period. Full stop. Let him go. So yeah, that's my opinion too, but we'll see how it goes. So below is a statement from Tricia Rojo Bushnell, again, his attorney. So today we saw two different approaches to prosecution. One committed to serving justice, aka prosecuting attorney Bell, who is seeking the vacating his sentence. He is the former prosecuting attorney. Like, he doesn't have to put himself out there to do this, but he is doing this because it's right and he wants justice done. All right, so today we saw two different approaches. One committed to serving justice, the other intent on winning at all costs. AG Bailey. Prosecuting attorney Wesley Bell's office acknowledged that Marcellus Williams' conviction and execution sentence are unreliable, that the previous administration's mishandling of evidence has foreclosed Mr. Williams' ability to conclusively prove his innocence at this time. So, did they do it on purpose, even, maybe? The prosecutors handing it over now? I don't know. But at this time, so making it conclusively uh, has foreclosed his ability to conclusively prove his innocence at this time, and that under these circumstances it would be unconscionable to allow his execution. Now, all the evidence that could have included or excluded him as the suspect, it's tainted, it's gone, we can't use it. So it's not ethical to execute him based on knowing what we know now. Meanwhile, Attorney General Andrew Bailey continues to make every effort to try to take this innocent man's life, including fighting the proposed resolution that would have brought finality to the proceedings while respecting the wishes of the victim's family. Quote, "We hope the Circuit Court will agree with P.A. Bell that the admitted constitutional errors in this case require Mr. Williams' conviction and execution sentence be vacated." That was August 28th, 2024. We wait ever so anxiously for the Circuit Court's decision. I hope, and pray that they make the right decision. But if they decide to continue his, or not, but to let his execution proceed as planned on the 24th, then we'll see where their interests lie, I guess. Is it justice? Is it winning? And then hopefully, that, if that, hopefully that doesn't happen and they accept this or approve this sentence being vacated uh, from Mr. Williams. But if they don't, then I am sure that there's going to be some kind of appeals in some form or fashion going to the Supreme Court. This is really ridiculous. I don't know why this AG is still going after them, even though the prosecutor's office is like, hey, no, no, that he's good. You guys got to let him go. So why is the government, the next level of government coming in and taking over? It makes you wonder. And it makes you wonder what happened to the knife. When did it get contaminated? Was it as they were turning it over recently to defense, as defense was trying to get it for DNA? Or did it get determined during the DNA testing that the prosecutor team was also part of it? I don't know. It's just, when did it come in? When did the prosecuting team's DNA get on there? Is what I want to know. And was it on purpose to potentially get him to win, basically, to win, to cover up that they got the wrong guy? I don't know. I'm not saying that that's what happened, but I'm wondering if it did. What do you guys think? It all seems pretty fishy to me when things like this happen, and it seems like an orchestrated, like a high level orchestrated campaign to like keep this man in prison, and I just don't get it, and to execute him. So let me know what you guys think. Thanks for watching. Next week we'll have another new case, and if there's anything new, if we have any in future cases, I'll do like a housekeeping right before and give you an update if there's anything new in the Marcellus case. So stay tuned to this channel. Please hit the like button. Make sure you're subscribed so you don't miss out, and I will see you guys in the next one. Take care. Bye now.